The next and the last speaker is Felix Zaharia. Felix Zaharia is a diplomat in the International Law and Treaties Directorate of the Ministry of Foreign Affairs of Romania, and he's also, and he's going to speak, I think, of his experience, the Vice Chair of the ESPO Convention Implementation Committee and the Rapporteur of the Basel Convention Implementation and Compliance Committee. Felix, the floor is yours.
Thank you very much, Professor de Chazurn, and thank you very much to you all. As you noticed, I'm not only the organizer, one of the organizers of this conference, but also an environmentalist. And in this respect, I wanted to tell you, I don't know whether you know it or not, newspaper from newspapers does not degrade in landfills. So if a landfill is tight enough, and it happens in many cases, then paper remains there for years and years. In the US, newspapers from the 30s were found intact, and you could still read those newspapers. So not to mention, of course, the trees that are felled, the bleach that is used to whiten the paper, and all the energy that is used to manufacture that paper. So putting all the documents online is a very good way to responding to this. And you can find the program and the invitation on the website of the European Society of International Law. We will post there as well the titles of the presentations we have heard until now, and we will hear later on. And if Professor Peters agree, we will also post her handouts online. So at some point I was asked whether I consider myself an international lawyer that is a believer or a strategist. And I first answered that I don't consider myself an international lawyer. There is a very long way to go till there, but I'm very grateful, and I need to learn a lot to be there, to reach that point. But I'm very grateful that I have the opportunity to learn from the great international lawyers we have here today with us. And from what I've just said concerning that paper I was mentioning, you might think, well, he's not an international lawyer, but at least he's a believer. Well, I want to convince you in my brief presentation, because we are already during the coffee break, that I'm also a strategist. Before going to that presentation, I will briefly want to thank our gracious hosts, Laurence Poisson de Chazurn and Professor Motok, and also to the institutions that have made this symposium possible. First of all, the European Masters in Human Rights and Democratization, of which Professor Motok is a director, and Professor Zlatescu is the coordinator. Then we also need to thank the European Inter-University Center for Human Rights and Democratization, where this European Masters program is held. I would also like to thank the University of Bucharest, the Library of the Romanian Academy, where we are, the Ministry for Foreign Affairs, the Constitutional Court, and all the other institutions that have made this event possible. So now, going straight into my presentation, I would like to tell you something about the decisions of compliance committee, and specifically the decisions of environmental compliance committees. When I first thought about the topic, I was also thinking about including the human rights treaty bodies into this. But then I discovered a very I really enjoyed an extraordinary paper by Professor Nolkamper here about treaty bodies and the effect of the decisions of compliance committees in national law. So I said I should, and you can find that even, I think, online. And I was thinking that I move the discussion to environmental treaties compliance bodies, and I was thinking of telling you something about the decisions that the implementation committee of the ESPO Convention takes in respect of state parties, and how those decisions can be implemented into national law by national authorities on one hand and by judges on the other hand. And you saw Professor Constantin was mentioning about the problem that judges have with the application of international law, and I believe the problem exists in respect of the decision of implementation committees as well. The committee that I have chosen is the committee of which I'm a vice chair, the ESPO Convention Implementation Committee. And this convention, the ESPO Convention, deals with the environmental transboundary adverse impact. It requires states to consult each other when they are undertaking projects that can have a transboundary impact on the territory of another state. For example, and I will use this example in case of a nuclear power plant. Building a nuclear power plant requires, under the ESPO Convention, the notification of other parties to the convention about this project, because a nuclear power plant can have a transboundary environmental impact, even if in many cases remote. Now, the compliance committee was created by the meeting of the parties to this convention for reviewing and helping parties to implement their obligations under the convention. And it works as follows. There are several methods for the committee to be seized with a matter. There are submissions, so a state can complain to this committee about another party's non-compliance with the provisions of the convention. And there is also the committee initiative. The committee, based on the information that it has available from whatever sources, you could also, for example, write a letter to the committee complaining about something that is happening either in Romania or a neighboring country, which you consider that breaches the provisions of the convention. The committee will analyze it and then decide whether to start or not the committee initiative. So based on these two ways of seizing the committee analyzes the situation and decides in a document called Findings and Recommendations whether that state complies or not with the provisions of the convention. So it finds the state in compliance or in non-compliance. But then there is another part of the document, which I said it was also recommendations. So the finding is of compliance or non-compliance, and there are also recommendations on what the state should do in order to be in compliance. And even in cases where the committee finds a certain state in compliance with the provision of the convention, it nevertheless says, puts there some recommendations for the state to follow in order to maintain that compliance, usually. These findings and recommendations of the committee are then sent to the party for comment. I will not go into the procedure, which also allows the party to entitles the party to a hearing. But these these findings and recommendations of the committee are then sent to the meeting of the parties. So they are not binding until the meeting of the parties approves them by a decision, by way of a decision. This decision is then transmitted to the party and to the party in question, and then everyone expects for that party to follow that decision. So I hope I was clear enough with the way things work. I missed many issues, but I hope I underlined the most important ones. And now I will go into the example. Maybe some of you know that when when the building of a nuclear power plant is authorized from an environmental perspective, there is a lifetime attached to the environmental permit. So that the environmental permit that is issued by the national authority says that the nuclear power plant will be built and function for a period, usually for 30 years. Slowly in Europe, we have started to be aware of the fact that more and more nuclear power plants that were built in the 70s, in the 80s, are asking, so the operators of the nuclear power plants are asking for the extension of the lifetime of those nuclear power plants. The practice until now has been that there should be no environmental impact assessment of the extension of a lifetime of the nuclear power plant. The committee, the current position of the committee and the current discussions with the committee, which has been seized by an environmental NGO from Ukraine about the building of a nuclear power plant, has been that there might be an obligation for state parties to the ESPO Convention to undertake an environmental impact assessment in respect to the extension of lifetime of a nuclear power plant. However, this goes against the current practice, the current International Atomic Agency practice, the current practice of countries not only in Europe, where this convention applies, but also around the world. So of course there was a huge uproar, especially of nuclear scientists, about this decision of the committee. The committee has not been very brave until now. It has only inserted a sentence in one of its reports, but findings and recommendations on Ukraine will follow. The question is, once the committee decides that there is an obligation under the convention to undertake an environmental impact assessment in relation to nuclear power to the extension of lifetime of nuclear power plants, what is going to happen? What is going to happen once we have this decision and once this decision is approved by the meeting of the parties? Let's first assume that it won't be approved by the meeting of the parties. Will it have any effect? This is a question that has been intensely debated over the years, but even the committee has said that its decisions and the decisions of the meeting of the parties are not binding on the state parties. So from this perspective, it should be rather clear. But if the meeting of the parties agrees with the findings and recommendations of the committee, then a new practice will arise. What will the national authorities do in respect of this? As we have followed the compliance with the decisions of implementation and compliance committees, there is a consistent pattern of state compliance with them. So states comply with, for example, in the case of the ESPO conventions, with the recommendations of the committee. Sometimes more quickly, sometimes slower, but they do comply with them. So national authorities, from this perspective, generally comply with the decisions of compliance committees. But then, and with the ESPO, in particular, the ESPO Convention Implementation Committee. But then, what will judges do if they are seized with such a matter? Now here, I will say what I, as a member of the committee, would like them to do. The reasoning, the main purpose of this committee, of the ESPO Convention Implementation Committee, but not only, is to help parties in implementing the convention. So a broad agreement exists in the committee, although it has not been yet sanctioned by the committee itself, that these decisions of compliance committees, of implementation committees, should not be viewed as binding decisions stating facts of law. Their main role is to help parties in implementing conventions. So a judge may look from this perspective on one side. At the same time, the committee, the membership of the committee is not only technical experts in the field of environment, in the field of building nuclear installations or any other technical installation, but it's also a committee that is a form of legal experts. And some members of the Secretariat of the Convention are also legal experts. So from this perspective, the documents that are drafted try to follow a legal reasoning, where a judge can find inspiration. And I will end it with this. Thank you very much.